Good morning, Mr. Mybeck. Good morning, everybody.
Good morning, Chair.
Yes.
Chair, as you know, the proceedings today and tomorrow were originally scheduled for the hearing of Bombardier's Rule 3.4 application, which you granted, allowing them to cross-examine 3 witnesses and to lead 2 witnesses of their own. You'll know that Bombardier relates to the Transnet stream. They were awarded part of the 1064 contract. You have been provided, Chair, with correspondence indicating that Bombardier wishes to withdraw its application and also to, in effect, take back the affidavits that were filed in the Commission. Bombardier is represented today by counsel. Perhaps I could allow him to place himself on record and then address you in relation to those issues.
Yeah, no, that's in order. If it's going to be convenient to speak from there, that's fine, but otherwise they can sanitize the podium and you go there. You can choose which one suits you, Mr. Van Zyl. But then the mic would need to be put on. Yes.
Chair, thank you. I hope to be quick. I'm Dirk van Zyl. I've been instructed on behalf of Bombardier Transportation, and I confirm what Mr. Myberg has said, that the intention this morning of my client is to withdraw the previous application and the right to cross-examine and lead evidence, and secondly, to request that we, and I'm not sure what the right terminology would be, but to uplift the tendered affidavits. And the reasons for that has been set out in a letter that has been sent to the Commission, which I would request permission just to hand up formally onto the record.
Yes, the registrar will take that. May I ask you to speak up a little bit? I think your voice is soft. Maybe it's because I think you are not short and the mic is far from your mouth.
I will do so, Chair. Chair, if I may briefly just place on record then what the circumstances were. Bombardier Transportation had in effect been taken over by Alstom SA as the new mother company. And Alstom has the strong principle that it adheres to, that it will not sponsor evidence to any commission or any authority across the world that it has not verified in accordance with its very strict standards of compliance. It's in those circumstances that we sincerely apologize for the inconvenience caused and the time taken, but my client is simply not in a position to sponsor this evidence today, and out of caution is withdrawing it to make its own investigations. And that's been fully explained in these letters, and I suppose in light of the recent events, we have to make clear that we're in a very much different position of not withdrawing or refusing the evidence, but simply indicating that we're not in a position to continue.
Yes. No, that's fine. I guess that technically, insofar as the right to cross-examine that Bombardier had been granted and the right to adduce certain evidence is concerned, I guess technically what you are asking for is for leave not to proceed with the cross-examination and not to proceed to adduce evidence.
As it is.
Because if it was before those rights were granted, then you could withdraw the application for leave to cross-examine. You could withdraw the application for leave to adduce evidence. So now that those were granted already, technically, you're simply asking for leave not to pursue the cross-examination and not to proceed with the leading of evidence in terms of that order.
Indeed, Justice.
Yes.
Chair, that is
No.
indeed.
Yes. No, that's fine. In regard to the request not to pursue cross-examination and not to proceed to adduce evidence, I have no difficulty granting leave. In regard to whether, as you say, well, the correct term, whether to withdraw or upload or whatever the affidavits that had been already lodged with the Commission, that might be more complicated than the other. Because to the extent that the affidavits are already in the Commission, it may well be that one can't say they should be taken away from the Commission, as it were, but it may well be that the new owners of Bombardier might, before the Commission completes its work, having had the chance to look at those affidavits, they might communicate with the Commission to say, if that is the position, to say those affidavits should not be seen as representing the current owners, the views or position of the current owners. So all I'm simply saying is, I'm not in a position to immediately say, I grant leave for you to take the affidavits away, because it might need more thinking. But what I think you might need to do is just reflect on how it should be done. Maybe you might communicate with the legal team of the Commission, and maybe ultimately there might be a substantive application to deal with the situation. Then I can apply my mind more fully, because in effect, that is evidence that has already been placed before the Commission. It's just that it's in writing, it's not oral evidence, but nevertheless it is evidence that has been placed before the Commission. So I would say reflect on it to the extent that you may need to reflect on it, communicate with the Commission's legal team, and at the right stage, then maybe something can be communicated to me, and then I can ultimately indicate what my final position would be. Is that fine?
We duly take note of that. Thank you, Chair.
Yes.
I can tell you that my client has already started the process of verification. I don't anticipate, from what I've seen so far, that process is going to be able to be completed timeously, but I can assure you, Chair, that my client will most certainly take the invitation and the what you have said seriously.
Yes.
It's most unfortunate that we've only at this short time had a process that then petered out.
Yes.
And then we now find ourselves here. But we will, most certainly, we take the work of the Commission very seriously, and to the extent that we can contribute, my client has given the assurance that it will.
Yes, no, that's fine. It may well be that all that might need to be done is that when the report is prepared, it should be stated on record that these were affidavits that were filed at a certain time, and that there was a request to at this time to take them out, or whatever the terminology is, once there were new owners, so that whatever is made of them is made in the context of whoever were the owners at the time. But you will get a chance to reflect and then indicate what your submissions will be.
As it pleases, Chair. Thank you.
All right. Thank you very much. I think then I have granted leave in regard to the two matters, and the other one is just left pending because it needs further consideration. Yeah. Okay.
Thank you, Chairperson.
Thank you.
Thank you, Chair.
Thank you. And anyone who wishes to be excused is excused.
Put all my things in place and
Okay. Take this until I'm told I need it. Yes, Mr. Soni.
morning, Chairperson.
Good morning, and good morning, everybody. Good morning, Mr. Sacks.
Morning, Chairperson.
Thank you.
Chairperson, you will recall that yesterday we had interrupted Mr. Sacks' evidence dealing with the flow of funds and the report he had compiled on that. Chairperson,
Yes.
I've reflected overnight and I've raised with Mr. Sacks that in light of the issues that the Commission is concerned with, there are certain details relating to when payments were made and what the amount was. In the long run, for the purposes of the Commission, it doesn't take the matter further, Chairperson. What we want is the overall picture. And but not only to speed things up, but also to ensure that we don't lose focus of what we want. So I've raised with Mr. Sacks, and I want to raise with you, Chairperson, that the approach I want to adopt to the rest of, or most of the rest of the report is for Mr. Sacks to confirm the correctness of what is contained in the tables with the commentary, and there are certain matters that are quite important. For example, who were the directors of the companies in concern, who were the auditors, and so on. So it will be those matters that we will concentrate on in the rest of the consideration of his report. And the next matter I want to raise with Mr. Sacks is, you'll recall, Chairperson, that in his evidence, Mr. Sacks said that there were 2 emails from Ms. Gaza that raised red flags before the contract had been signed, of course, after the award had been made. Mr. Sacks has now managed to get those emails. They are contained in the affidavit that Mr. Hodge filed in response to what Mr. Montana had alleged in his incomplete affidavit. So I will ask Mr. Hodge, because I think they are quite reflective of what the contents of those emails, how strong the message was. And then I'll leave that part, and then I'll go on to the CM hundreds, because as I indicated to you yesterday, Chairperson, some of the investigations that Mr. Sacks did were based on what was said in the Swifambo application. Now, in the CM100s, or notes to the CM100s, that Mr. Mashaba lodged with the Master's Office, he reflects or indicates what the funds were for, or where he is not happy about payments that were made by Swifambo. He indicates what that is. Now, Chairperson, for the purposes of the Commission, and in my view, we needn't go, we can dispute the correctness of that, but we are not in a position to do so at the moment. But what Mr. Mashaba says in those CM hundreds, Chairperson, is for the purposes of the Commission quite interesting. And that's effectively, and I don't mean to be crude, but that's from the horse's mouth, as it were. And we can take that as representing his position, because the CM 100 is effectively an affidavit.
No, that's fine.
Is it okay if I proceed?
That will be in order, yeah.
Mr. Sacks, you've heard what I've communicated to the Chairperson about the approach to be adopted.
Yes, Chairperson.
Okay. Now, we finished at page 902 of Bundle L. That is still your report yesterday, is that?
Yes, Chairperson.
And
I'm sorry, where are we going to resume from on the...
from page 902, Chairperson. 902 of SS24, Bundle L.
Okay, 902. Okay, thank you.
Now, at 14.2.2, you summarize the amounts that Swifambo received and paid. Would it be correct that you thereafter in Table 5 summarize how Swifambo had utilized the funds it had received from PRASA relating to the main beneficiaries whom you identified yesterday?
That is correct, Chairperson.
And Table 5, if you could just indicate that right at the top you say the amount received from PRASA was 2,650,000, 2,650,207,950 rand and 29 cents, and then it made disbursements to Vossloh, Mashaba, or entities linked to these persons. How much was paid to Vossloh?
Chairperson, the amount is 1,873,474,161 rand and 62 cents.
And do Mashaba and Mashaba linked entities?
Chairperson, the payments linked to Mashaba linked entities is 102,928,001 rand and 75 cents.
And Mr. Mashele?
Chairperson, the payments linked to Mashele, 39,054,840 rand.
And then there were other disbursements in the region of 231 million, or just a little more than 230.
That's correct, Chairperson.
And what was the balance in Swifambo's accounts as at the 30th of November 2015?
Chairperson, the balance at 30 November 2015 was 111 million rand, 376,943 rand and 89 cents.
Now, just to put the rest of the report in context, The rest of the report actually, in respect of each of those main figures, breaks down which were the entities. In other words, this is the big picture, and now in the rest of the affidavit, you indicate that this is the amount that went to Mr. Mashaba himself, to this entity, that entity, and that entity. Is that correct?
That's correct, Chairperson. These are just summaries that I included up front to assist the police in understanding collectively what money flowed. However, as Council refers, each transaction, as is included in the bank statements, is detailed in the rest of the report.
Now, we'll go through those to the extent that they are relevant. Let's then look at Table 6, which is a point you made yesterday, that on the 5th of April 2013, Swifambo received the first payment from PRASA.
That is correct, Chairperson.
And then you look at how that money was distributed. Is that correct?
Chairperson, it's standard procedure for these flow of funds analyses, specifically in this type of case, is to investigate the time frame when money is received and when money is paid. And specifically, as Council refers in Table 6 under paragraph 14.3, I noted that, as was discussed yesterday, there was quite an extensive time gap between when Swifambo received its first payment from PRASA into the incorrect account, Swifambo Rail Holdings, and when it made its first payment to Vossloh, and which was 116 days later.
And in with the rest of the flow into Swifambo's account, whether Swifambo Holding or Swifambo Railing, you indicate when the funds were received and how many days later money was sent to Vossloh.
That's correct, Chairperson.
And you confirm the correctness of those figures.
That's correct, Chairperson.
The one that stands out is the 160-day period between the first payment that Swifambo received and the first payment made to Vossloh.
That's correct, Chairperson.
And the others are in the region of 3 weeks and sometimes 1 week and so on.
That's correct, Chairperson.
Now, in regard to the 116-day period between when PRASA received, when Swifambo received 460 odd million from PRASA to the time it made the first payment to Swifambo, you've done a calculation looking at the bank accounts of what amounts it had distributed to other people.
That is correct, Chairperson.
And that is what reflected in the first document you presented yesterday, Chairperson. You'll remember we had the pictorial representation.
Yes, I still have.
Okay, we just want to go through that because it may be quite revealing, Chairperson. All right, could you just, you just need to give the dates and to whom the payments were made and what the amounts were.
Chairperson, we're looking at, I think, the first diagram, page 1.
Page 1, okay.
It's titled Swifambo Flow of Funds, Timing and Utilization of First PRASA Receipt of 460 million on 5 April 2013. The top left corner. Okay.
I've got it.
Chairperson, as Council has requested me to explain this document, as you can see on the document, on the left-hand side, it shows money flowing in from PRASA on 5 April 2013, 460 million rand. And that, as I denoted, it's paid into the Swifambo Rail Holdings Standard Bank account. And I note that this money, in terms of the contract, should have been paid into the Swifambo Rail Leasing. Then, as you see the outflows on the right-hand side, I've summarized per the bank statements. If we work our way from the top, it includes the date, the recipient of the money, and the amount of the money. And there's on this document shows 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16 recipients of payments, and the last payment, the 17th and 30th of July 2013, is Vossloh for 290 million rand. So the point of this document was to explain that on 5 April 2013, PRASA paid 460 million rand to Swifambo. On the 30th of July, 116 days later, Swifambo paid Vossloh 290 million rand. The balance, the difference of approximately 170 million rand, was in the main paid to the entities and individuals which have been linked, which we discussed yesterday. So, for example, the first payment on 8 April 2013, AMCE, which is AM's Consulting Engineers, which is Mashaba's company, received 5 million rand. So, as I denote on this document, within 6 days of the receipt from PRASA, Swifambo paid 102 million rand out of the business to Mashaba, Mabunda, Mashele, WKH Landgräber, Trust, which is Mashaba's linked to Mashaba, Enerwaste Company, which is linked to Mabunda, and Khosi Sabela, Musa Capital. So, Chairperson, without getting into too much detail, just for summarization purposes, in the bottom left-hand corner, I included the totals that all these individuals or entities received. And the point that this document is trying to say is that before Vossloh received its first payment of 290 million rand, 116 days after PRASA had paid Swifambo, 150 million rand was in fact dispersed to Mashaba, who received 30.5 million rand. Mashele, through an entity called Barn Wheels, received 28.32 million rand. Mabunda, through an entity called Enerwaste, received 23.68 million rand. Parish, through an entity Musa Capital, received 13.5 million rand. WKH Landgräber, who again were the auditors of many of these linked entities, and Swifambo Rail Leasing's auditors, received 16.5 million rand. Knowles Hussein received 10.4 million rand, and Nkosi Sabelo received 28.5 million rand, which totaled 151.4 million rand. These recipients received money before the first payment to Vossloh was made. And in context of, if you recall, Chairperson, the profit that Swifambo was, the margin they should have made of 180 million rand, just on the first payments alone for funds received from PRASA, greatly exceeded the profit that Swifambo ought to have earned over the duration of the entire contract.
Yes. Now, I think this pictorial representation starkly represents the point you are making. And if I could put it in a slightly different context, this was the priority of creditors as far as Swifambo was concerned.
Chairperson, the council uses the word creditors loosely. I think this is the priorities of the directors or influential people.
Certain recipients.
Yes, Chairperson.
Perhaps that is a better word.
Yeah.
Yes.
Yes.
Yesterday, I said to you, one of the figures that had stuck in my head was a payment of 10 million rand to Landgräber. In fact, it's 8.8 million rand on the 9th of April, and then further payments of 1.2 million rand, and then 4.3 million rand, and then 2.2 million rand.
That's correct, Chairperson.
They were quite busy on the 9th of April.
Yes, Chairperson.
Yes. Then at page 906 in paragraph 14.4, you indicate that the payments that were made to Vossloh for the locomotives, and you've already indicated that it was a little more than 1.8 billion rand.
That's correct, Chairperson.
This, though, is something I want you to explain to the Chairperson. What was the source of this information?
Chairperson, the ultimate source is Vossloh themselves confirmed to the South African Reserve Bank, if I stand to be corrected, they in fact received this money. And using that confirmation from Vossloh themselves, I was able to marry up the payments out of Sufambo's bank accounts, even though, if you recall, I was missing one or two pieces of information. But because Vossloh had confirmed the amounts, I knew that those amounts had indeed been paid.
So it's Vossloh who confirmed to the Reserve Bank, and that's the information you derive. I mean, you based Table 7A upon, but you've obviously checked it against withdrawals from.
Yes, Chairperson, I've confirmed it as Council said.
So the other information is contained in your analysis of bank, is derived from your analysis of bank accounts. This, though, comes from Vossloh itself.
That's correct, Chairperson. Sorry, Chairperson, just stand to be correct, it was actually National Treasury that they confirmed the amounts to. Excuse me, I was just got a bit confused between the two sometimes with the detail.
Yes, I think you do say that in paragraph 14.4.2 of your report, that it is Treasury.
Yes, Chairperson.
All right. Then at 14.4.8 on page 908, you look at the payments that Vossloh made to Sufambo, and you say that totaled 811,508 rand and 59 cents, and you break down the different payments that were made. Can I ask you, were these payments, the concern, well, not the concern, but what stood out for me is Vossloh is doing things for which Sufambo needs to pay it in terms of Sufambo's contract with Vossloh. Is that correct?
That's correct, Chairperson.
Now, this seems to suggest that it was Vossloh, the worker, who was paying Sufambo, the actual paymaster eventually.
That's correct, Chairperson. As I stated in my report, initially I did state in my report that the 811,000, which we discussed yesterday, which were these amounts that were flowing into Sufambo's bank accounts prior to the PRASA receipts, and as I stated in my report, these funds were ostensibly used to fund the setup costs of the Sufambo office. I did state in my report that obviously these are subject to confirmation and will have to be investigated further.
Now, you also said yesterday, and you can just confirm it, but it's in your report, where you say that the Vossloh's contract with Sufambo was signed on the 4th of July 2013.
That's correct, Chairperson.
Now, if you look at these payments, all except the fifth one were made to Sufambo before the contract was signed.
That's correct, Chairperson.
And those were the smaller amounts. The bigger amount on the 17th of April 2014, that's almost a year after PRASA had been paying Sufambo, Vossloh makes a payment to Sufambo of 488 odd million rand. 488,000 rand.
That's correct, Chairperson.
Is there any indication what that was for?
Chairperson, the description contained within the Sufambo Rail Leasing bank account, which these tables include the bank statement, account details, who received the money, the date, and the description and the amounts. The description says electronic banking payment, FR Vossloh, rent and other payments.
Oh, so Vossloh was paying for the rent in the meantime.
Chairperson, we interpret the bank statements as you read them.
Yes.
The the actual commercial rationale for the payment, obviously subject to confirmation, but on face value, it appears that Vossloh was paying rent for Swifambo.
I tell you why I'm intrigued by this, and it's only occurred to me now, that's why I didn't raise it with you earlier. If you turn to table 7A on the previous slide, you will see that according to Vossloh, it had received money on the 1st of August 2013, it had received money on the 2nd of January 2017, the 17th of January 2017, the 19th of...
Sorry, Council, 14.
14. The 19th of May 2014, and the 8th of July 2014.
That's correct, Chairperson.
And then it then makes this payment on the 17th of April 2014.
That's correct, Chairperson.
Well, obviously you can't explain, but does that not sound odd to you?
Again, Chairperson, at face value, it sounds odd, as to use Council's word.
But let me ask you a slightly different question, which is not contained in your report. It seems, and that's the reason I'm examining, and I take it that's the reason you included the payments that Vossloh made to Swifambo over this period, over the period 2012 to 2014. Is there anything you have uncovered as to the benefit to Vossloh of this contract, besides the money?
I have, Chairperson, in the course of the worksman's investigation, intelligence is obviously performed, and when we were looking at, the team was looking at Vossloh as an entity and the contract itself, we were looking at the Vossloh financial statements, and I'm assuming, Council, that's what you were referring to. And if I may, which I found it quite revealing, and it was reported at the time during the course of the worksman's investigation, as to how Vossloh themselves, the greater Vossloh group, because Vossloh España, the locomotive manufacturer, is a subsidiary of the Vossloh group at the time. I do understand that there's been a name change or transactional activity in that group to another entity. I'm not familiar with those details, but at the time when we were doing the investigation, and if you would indulge me, I have briefed Council what those financial statements actually said, and if you allow me to, I can read them into the record, which is quite revealing in terms of the value that Vossloh placed on this contract, and in light of the funds flowing to Vossloh, and as my report will state, money flowing over and above these payments that we talk about, the 800,000 Rand, be it is a lot of money, there was significantly more funds, much more funds that flowed into South Africa from Vossloh, not through Swifambo, which Council will deal with. But if you bear with me, these are what I call pertinent extracts from the public audited Vossloh AG financial report. And
for what period was that?
This is for the financial period ending 31 December 2013. And they signed the contract with, Vossloh signed the contract with Swifambo in July 2013. So this is 6 months later. I recall at the time when we were doing the worksman's investigation, we weren't familiar with that contract between Swifambo and Vossloh. That contract was only revealed later in the discovery in the Masara affidavit. And we were trying to establish what the value was that Vossloh was earning. What was the price that they were earning? We knew what price was paying Swifambo. And I'll read the actual extracts from the financial statements. With reference to Vossloh's stock per page 8 of the financial statements, with the announcement in the beginning of October 2013 of a major order from South Africa, Vossloh gained renewed interest of investors, and the stock significantly recovered through the end of November to prices above 70 euros. So obviously the inference is the major order from South Africa has a positive impact on the share, assuming stock price, in South Africa we refer to a share price, has a positive impact on the share price, which significantly recovered. The next quote, with reference to Africa operations per page 18, in fiscal 2013, Vossloh succeeded in booking a mega order from the South African company Swifambo Rail Leasing for 70 locomotives. The contract is worth a total amount of around euro 250 million. And that was the first indication at the time of what Vossloh was earning, 250. We knew Swifambo PRASA was paying 267 million euros. Again, if you recall, Chairperson, this was a euro price contract, even though it was titled 3.5 billion. The next quote, with reference to Vossloh Transportation Systems per page 74, the winning of a major contract from South Africa in the third quarter of 2013 for 70 locomotives of Vossloh rail vehicles in the amount of 250 million euro contributed significantly to this development. With reference to Vossloh Transportation Systems per page 75, thanks to the major order from South Africa, the order backlog of Vossloh rail vehicles as of December 31, 2013 was an extraordinarily high level. The orders received in purely mathematical terms extend well into the year 2016 and prove the Valencia location with a positive sales outlook for the coming years. And the last quote, with reference to Vossloh Electrical Systems per page 76, as was already the case in 2012, the largest contribution to sales outside of Europe was in South Africa. So, Chairperson, at the time, as the Worksman's investigation was being performed, this was very revealing in terms of understanding how significant this contract was, not only to Swifambo, but to Vossloh themselves. And when we deal with the flow of funds into South Africa from Vossloh, it puts it into context. Why it was very important for Vossloh to, in fact, get this contract.
It may be, and I know it's contained in a different part of your report.
I'm sorry, Mr. Sonny.
Please.
Do I have that page document you are reading from?
No, I don't think so, Chairperson.
I think we should get it, Mr. Sonny,
Yes.
and it could be admitted as an exhibit.
As you
And I'll forward the Commission the financial statements for Vossloh AG as well, from where these quotes come from.
Please, yeah.
We'll do it in a separate supplementary affidavit,
that's fine.
so it doesn't.
That's fine.
And Chairperson, I must apologize. I only found out about this a couple of days ago.
Yes, no, that's fine. I think it's important.
Absolutely. It puts the whole picture in perspective.
Yeah.
But I know, Mr. Sacks, you deal with that later. But maybe it is a good time, just because we are dealing with the issue of Vossloh payments, because you've mentioned them, that they made payments to Swifambo. I'd like you to turn to page 953 of your report. Page 953, Chair.
953.
Now, you don't have to read this. Will you indicate to the chairperson what you deal with in the context of what you've just been saying? You were saying there were major other inflows into South Africa from Vossloh. So will you tell the chairperson what this is?
Chairperson, the Worksman's investigation team, at the time we performed the investigation, was provided with a report which was styled Provisional Report on the Passenger Rail Agency of South Africa Matter. This report was prepared by the Compliance and Enforcement Division of the Financial Surveillance Department, dated 15 February 2017. And I stand to be corrected, I think that's of the Reserve Bank. And in summary...
Sorry, just for the record, what is the Compliance and Enforcement Division?
The
Financial Surveillance Department? To which department does it belong?
Chairperson, again, I think it's to the South African Reserve Bank. It's a department within the Reserve Bank, and they were obviously in a position to ascertain money flowing into South Africa, as all money flowing in and out goes through the Reserve Bank.
And generally, what is the purpose of monitoring that?
It's compliance and foreign exchange compliance and enforcement, I would understand.
Would it not also be to monitor if there are suspicious inflows or outflows of money, which all countries in the world, just given the world we live in now, are required to do?
I confirm with the Council, Chairperson, on that view. So, in summary, this report confirmed that an amount of 88,991,291 rand and 39 cents, flowed into South Africa from Vossloh. And my report includes extracts of this said report. And if you indulge me, Chairperson, I can say that an entity with the name Vossloh Kipper, which I understand is an Austrian division of Vossloh AG, made 6 payments to CIA Rail Infrastructure Solutions and Technology between December 2011 and September 2013, totaling 13.6 million rand. The category for these payments is reflected as legal, accounting, management, consulting, and proceeds for management consulting. And my report includes the details of these payments. And Chairperson, Vossloh España, which we understand is obviously the Spanish subsidiary which manufactured the locomotives, made 6 payments to an entity, S Investments Pty Limited, between February 2014 and September 2015, totaling 75,328,121 rand and 57 cents. Category of these payments is reflected for proceeds for management consulting service and architectural engineering and other technical services. And as I state in my report, considering the material nature and amounts of the payments listed above, specifically as the payments were ostensibly made to Mabunda companies, this report and the content therein, being this Reserve Bank report, needs to be investigated further. But ultimately, this report confirmed that approximately 89 million rand was paid by Vossloh into South Africa to Mabunda-linked entities, and which I understand which Council will examine further, that the Liquidator's report deals with this aspect as well.
Now, you say in the last paragraph of your report, considering the material nature and the amounts involved, 75 million rand being paid by a person who receives, in their words, a mega contract from South Africa to an individual who you say is significant. And why do you say in this context Mr. Mabunda is significant?
Chairperson, as we've explored, Mr. Mabunda and his entities, linked entities, received significant funds from Swifambo. Not only that, Mr. Mabunda's linked entities were significantly involved in the tender. If you recall, Chairperson, one of the first items in the tender was to pick up the tender documents, and someone from S Group collected the documents themselves. And that was the start of the flow of Mabunda-linked entities through the whole, from the inception of the tender to the awarding of the tender to ultimate outflow of funds, and further to these flows from Vossloh into South Africa of 89 million rand. And
in terms of the analysis you did of the major, I don't want to call them creditors anymore, but the major beneficiaries of the outflows from Swifambo, Mr. Mabunda and his company are major beneficiaries.
Chairperson, the flow of funds analysis shows that Mabunda-linked entities received from Swifambo over the course of the time of the analysis 54,651,981 rand. And the entities include names such as Enerwaste, the CIA Group entities, and Sovo S Group.
Yes. So that would mean that in respect of this contract, Mabunda Mr. Mabunda and his companies received more than 140 million rand. Take the 88,4 plus 54 that you're talking about.
That's correct, Chairperson.
That's more than the profit that Swafambo was going to make out of the entire deal.
As per the contract, yes, Chairperson.
And I think you said yesterday, but you will tell me if I misunderstood, I think, and you said yesterday, for really doing nothing.
Yes,
Other
Chairperson.
than being the middleman.
You are correct, Chairperson.
Yes.
So, adopting the approach that we indicated that we would just deal with the big amounts.
I'm sorry, Mr. Sonny.
As you can see.
Can I ask this question? And your being an accountant and a forensic investigator might enable you to answer it. What are the chances that the price for the locomotives that was quoted to PRASA was inflated in order to make provision for amounts that would have to be paid to the middlemen by Vossloh? In other words, I don't see that if I'm going to manufacture trains to sell to him, if their true price is 100 rand, then my profit is provided there. That if I allow you to be the middleman, I'm going to still quote 100 rand, especially if your commission is going to be quite substantial. It looks like I would have to inflate the prices so as to accommodate what I must pay you and still make a reasonable profit. In terms of your own experience, in terms of your analysis, is that something you are able to answer, even if not definitively, but in terms of probabilities based on your experience?
Chairperson, it's a very good question. I think the first thing that you can say is if PRASA secured the trains directly from Swafambo themselves, assuming Swafambo qualified to provide, they would have paid a significant 120 million rand less, which is a significant amount. It appears to me, without knowing the information and with in fairness to Swafambo themselves, we haven't asked them the question, we haven't investigated. Did you charge a fair price to Swafambo? Did you give them a discount to enable them to make a markup? That obviously would have to, those conversations would have to take place, and that is why we were reporting, the Worksman's investigation team was reporting this very fact to go to Vossloh. Let's ask those questions to Vossloh. It looks like, based on how this contract, as we have seen how this contract evolved, there didn't seem to be a concern on the PRASA side, PRASA management side at the very least, what they were paying. It seemed that once the contract price, the amount of 3.5 billion rand was fixed, that's the number. However many locomotives we get for 3.5 billion rand, initially it was 88, then the rand weakened, now we're getting 70. It seems like price was irrelevant really, in a sense, on the per unit price. It was just the contract price. I think you asked a very good question, and I certainly think, did PRASA pay more than the going rate for a locomotive? I wasn't privy to what the other tenders bid for their locomotives, and that is certainly something that would have to get would have to be looked at in context of the whole. I hope I answered
Yeah.
Your question.
No, that's fine. It may well be that trying to establish what similar trains may have been sold for elsewhere by Vossloh or by its competitors at that time may help to say, because as I see it, if Swifambo had no previous experience of in this sector, or maybe in any sector, in this sector, maybe whatever prices they quoted were based on what Vossloh may have told them, because they knew they were going to get them from Vossloh.
So in other words, Chairperson, they didn't act in the best interest of PRASA, they just accepted whatever price that Vossloh was quoting them.
Yes, but obviously the responsibility to act in the best interest of PRASA started with the people who agreed to the price at PRASA.
That's correct.
What homework did they do before they agreed to the price? Was this the going rate? Did they compare with other manufacturers internationally or whatever, or did they just take whatever price was quoted to them by Swifambo? So it would be interesting. I mean, I don't know if you have worked out what percentage of the whole amount paid by PRASA for these trains went to Swifambo in terms of all these amounts, including those that may have gone to Siangena and so on. What percentage in the end?
Swifambo, Chair.
Sorry?
Swifambo.
Yes, Swifambo. I think I saw in one of the pages some money that came from Vossloh Kip or something.
Yes.
Going to Siangena.
It was Siaya.
Siaya, no, yeah, I mean Siaya. Well, Mr. Soni knows that for quite some time I kept on confusing Siaya and Siangena. Yeah, so it would be interesting to see what percentage went to, ended up with Vossloh, what percentage ended up with Swifambo, Mabunda, and other people connected with Swifambo.
I think, Chairperson, it's fair to say that the majority of the 3.5 billion rand was going to end up in a foreign company. 1.8 billion rand was paid to them for the delivery of 13 locomotives. And I know during the Worksman's investigation, we were looking at that aspect in terms of how PRASA, the delivery of locomotives didn't accord with the money that was getting paid. It was almost like PRASA was paying up front. It was not a favorable contract to PRASA. They took on tremendous risk, performance risk. I understand there were issues with the performance bond, which I understand to be that if the supplier fails to deliver, how does PRASA recoup their money? And the whole contract itself was not focused to PRASA's best interest. And so in terms of just 13 locomotives coming for 2.6 billion rand being paid, of which majority of it went to Vossloh, I think it just stands on its own in terms of, well, PRASA was heavily exposed just on that basis alone in not getting essentially what they paid. But never mind that the locomotives were not suitable for the South African rail network as it was dealt with in Popo Molefe's, or the applications judged by the SCA.
Yeah, it would be interesting to know what price Vossloh would have quoted if they were dealing with PRASA directly.
I think it's a very good question, Chairperson.
Yeah. Okay, all right.
Into that mix, Mr. Sacks, one must also put this, because you raised the question, well, it looked an unfavorable contract. At the time PRASA contracted with Swifambo Swifambo had not yet contracted with Vossloh because PRASA's contract with Swifambo was concluded on the 25th of March, and Swifambo's contract with Vossloh was conducted 3 months later.
That's correct, Chairperson.
So even if PRASA had asked Swifambo, what is Vossloh going to charge, Swifambo could not give an answer because there was no contract between it and...
Yes, Chairperson, that's correct. This was dealt with extensively in the Popomalefa affidavits as well.
But I mean, it reinforces the point you made, that PRASA just didn't care.
To put it bluntly, Chairperson, that's probably a fair summation by Council.
Yeah, it's very worrying. I mean, people are appointed to important state entities like PRASA. They're in high positions. They get paid quite well to look after the interests of the entity. But by the way this contract was handled, it does look like the interests of PRASA were subsidiary to something else. It's very worrying.
Yes, sorry, Chairperson. I didn't mean
No, I'm done.
Yes. In regard to the payments that Vossloh made to CIA, which were flagged by the Financial Surveillance Department, when your report was finished, did you send the report to them to say, look, you flagged this, should you not look at this further? Or whose job, so what I'm asking really is, whose job is it to pursue such information when you get more damning information or more suspicious information?
Chairperson, I think the obvious answer would be law enforcement themselves. Hence, I included this very important finding in my report. Again, if we look at the genesis of this report, this was just my preliminary findings. No, it was obviously intended to move forward from there. Say, well, look, this is what we've got thus far. Here is the evidence we have received thus far. These are findings. These are areas of focus. And I would imagine that these inflows from a foreign company into South Africa to these individuals and entities should have been or would have been a key focus of a law enforcement investigation.
So you would have expected the Hawks to take this up and say, well, look, you flagged this, we've now got this further information.
At the very least, yes, because that's where my Chairperson, where my report went to.
Do we know, Mr. Soni, whether, in the light of the High Court and Supreme Court of Appeal judgments in Swifambo, which have been there for quite some time, the CIA one is recent, isn't it?
Yes, the Siangena one.
The Siangena one, yeah.
Sorry,
whether government or PRASA has done anything to try and recover some of the money it has lost through these contracts from its officials who made certain decisions which appear to have either at best for them reckless or grossly negligent, or may well have been because of some other agenda. Do we know whether anything is being done by, other than attempts to obtain from, I mean, Swifambo was liquidated, isn't it?
Yes. Chairperson, to the best of my knowledge, not. Because it's not a question that was pertinently asked, for example, to Ms. Ngoyi, who would have known as the head of legal and compliance. but it is a question that must expressly be asked to her, so I can respond to that at the next sitting, or certainly in a memo to you, Chairperson, and then we can take it up. But, then you would know formally what the correct answer is, Chairperson.
Because how much of the money that PRASA did pay out at some stage has come back?
63 million.
Sorry?
63 million rand. That's what the liquidator seems to have, yes.
Yeah, obviously that's a far cry from
the 3.5
from the
billion.
billions. Yes. Yeah, that were paid out. I think that the entity should be looking at investigating the possibility of suing everyone who may have made decisions that resulted in these losses,
Yes.
in circumstances where those individuals are not able to give proper explanations for their decisions.
Well, if I could, Chairperson, and I just am using the opportunity because you've raised it. One possibility is when there is a self-review to join some of the officials who were involved so that they can't hide behind the winning contractor, as it were. And then we're left in the situation where the High Court is faced only with the version of the organ of state, and it can't identify officials because there has been no attempt to say, but these are the officials, and this is what A did, this is what B did, and this is what C did, and that's why we want you, the court, to hold them responsible for it.
No, that's true. And any of those officials who is able to place before PRASA or before, let's start with PRASA, before PRASA evidence that there was nothing wrong with the decisions they took, and PRASA is satisfied, that's fine. They don't get sued,
Yes.
you know.
Yes.
Or if they don't put that before PRASA and they are sued, then they can place that before the court. But they can explain to PRASA to say, well, I made these decisions on the basis of this information, and it seems to me it was a reasonable decision to make in these circumstances. But if their explanations are not satisfactory, then PRASA could consider suing them.
Indeed.
Yeah, because this is a lot of taxpayers' money.
It is something that has given me sleepless months, Chairperson.
Yes. I think yesterday Mr. Sacks referred to a page in the course of his evidence, a page in the report which reflects that a certain Ms. Gasa, I think,
Yes.
wrote emails to Mr. Sfiso Buthelezi
Yes.
and to Mr. Montana, warning them about certain dangers in relation to concluding
Yes.
this contract, if I'm not mistaken.
It is so, and Chairperson, on reflection, and having been advised that those emails are in fact available, I've made a copy of each of those two emails. I think one is on the 6th of November and the other is on the 20th. I've made them available to Mr. Sacks, and I'm going to ask him.
Yes.
Because you will recall that was before the contract was signed.
Yes.
And those
yes.
emails,
Yes.
so it reveals, Chairperson, the very point you are making, that now you are told by a person who is a member of the board that this is really dangerous waters, and you take your ship into those waters. And of course, the waters eat the ship up.
Yes, yes. Okay.
Because I see it's just after 11:15. Do you want to take the tea, gentlemen?
Let's take the tea break. We will resume, it's 20 past. We'll resume at 25 to 12.
As you please, Chairman.
We are Chairman. Okay, let's continue.
As you please, Chairperson.
I didn't say this when we started, Mr. Sacks, but I just mentioned it now, that the oath you took yesterday continues to apply.
Yes, Chairperson.
Yes, okay, thank you.
Now, I interrupted the flow of evidence leading to where you identify in detail what each of the beneficiaries and the entities got, because we were dealing with the Vossloh payment to Mr. Mabunda and his companies. I want to take you back now, and this shouldn't take us too long, Mr. Sacks. At 14.5, you deal with the payments that were made to, or you call it payments linked to Mashaba. That's Mr. Mashaba personally and to entities in which he has an interest.
That's correct, Chairperson.
And if you look at 14.5.5, you set out the four beneficiaries into which you can divide Mr. Mashaba's interest.
Yes, Chairperson, it's to assist council, it's the four bank accounts in these entities' names.
Sorry.
Yes.
Yes, okay. And the one in regard to AM Consulting Engineers appears at Table 8, which is on page 913. The one on Morocco Makolele Trust appears at Table 9 on page 914. The one for Mr. Mashaba himself appears at Table 10, page 915. And the one for Vianati Properties appears at Table 11 on page 916. Is that correct?
That's correct, Chairperson.
I just want to ask you for, and I don't want to be panicky, but it is your report. In 15.5.3, you say there were 9 payments, but when you look at Table 10, it appears there were 10. That obviously is a typographical.
Yes, Chairperson. As I say, it was a draft report. These little errors have been picked up on finalisation.
I just wanted to make sure that
Council's correct. There's 10 payments.
Okay.
Is it possible to have a page somewhere that just records that correction?
I could lead him on that, so so the record will reflect that.
Yeah. No, what I'm thinking is, if you lead him, which you must do,
Yes.
one will see that in the transcript.
No, not
But
in
if
the,
one is looking in the bundle, one might
Yes.
not
No,
get
no,
it.
no,
So
you're quite right.
it might be helpful to have a page, maybe even if it's at the end,
Yes.
that says in his report
Yes.
at page what, this is what it says, but actually it's not
actually
correct. This
yes.
is the correct position.
Yes. As you please. Then we go to the payments, and that's 14.6. The payments made to into the bank accounts of Mr. Mashele and entities in which he has an interest.
That's correct, Chairperson.
And those appear at tables 12 and 13 at pages 919 and 920 respectively. Is that correct?
That's correct, Chairperson.
And you confirm the correctness of what's contained in those tables?
That's correct, Chairperson.
Now, I'm sorry, I was trying to move on. There are matters that you mention in relation to other interested parties. Can I just take you to paragraph 14.5.7.2 at page 911, where you make the point in regard to AM Consulting Engineers, the auditors are WKH, Landgräber and Company.
That's correct, Chairperson.
And why do you find that to be significant?
Chairperson, again, WKH Landgrepe, a bank account in the name of WKH Landgrepe, received significant flow of funds from Swifambo in the amount of approximately 27.9 million rand.
And then you note at paragraph 14.5.73 that the directors of AMC are Mashaba, a Mr. Moloko Floyd Seboni, and Van Grebe Secretarial Service.
In the capacity of company secretary.
Company
Yes, yes, Chairperson.
Is that usual to have them, or were they just the company secretary?
I think they were just the company secretary. Again, the involvement of WKH Landgrepe was subject to further investigation, but
Yes.
as stated, they were the auditors.
What you were trying to show is this appears to be a link between that firm and Mashaba's entity.
And the flow of funds. Yes,
Sorry,
Chairperson.
and the flow of funds.
Yes, Chairperson.
Yes. All right, then at 14.6, you deal with the flow to Mashele. We've been through that, tables 12 and 13. And in regard to Barn Wheels, you say their registered auditors are Van Wyk auditors.
That's correct.
What is the significance of that?
Chairperson, at the top of my head, if I recall, I was just recording all these entities, who the directors and who the auditors were, but I do believe that Van Wyk auditors did crop up amongst the entities. They weren't specifically beneficiaries of funds, but I was just stating facts, because in an investigation, if further information is required, if I state who the auditors are as recorded on CRPC, it would give I guess the police at the very least, or whoever else is involved in the investigation, areas of further examination. If we need financial statements or we need queries, we go ask the auditors. So I was just stating this information just to be factual within my report.
All right. I think their name crops up as auditors of other entities as well, in fairness. That's how I read
That's correct, Chairperson.
the report. All right, then at 14.7, you deal with payments linked to Mr. Mabunda and his entities.
That's correct, Chairperson.
Now, I just want to make this point because you may not have been aware of it. At paragraph 14.7.3, you say that the amounts on your investigation, you say this is background, that the CIA, well, different companies in the CIA group received the payments mentioned, 26 million rand, 23 million rand, and CIA engineers, the amount to be determined. I just want to point out to you, when Ms. Ngoyi gave evidence about the CIA group, she said they had done, she'd been asked to do that calculation, and she said that from about 2009, they'd been paid a total of more than R1 billion. Chairperson, you'll recall that evidence from Ms. Ngoyi.
From PRASA.
From PRASA,
Yeah,
yes.
from PRASA,
Yes.
Chairperson.
So I just, there's nothing wrong with this, but a different investigation from PRASA itself revealed that. Anyway, at 4.7.9, you set out the amounts paid to each of the entities, and these are detailed at tables 14, 15, 16, 17, 18, 19, and 20 from page 924 to 934.
That's correct, Chairperson.
And you confirm the correctness of all of those?
Yes, Chairperson.
Then the person whose name you flagged earlier, Mr. Landgräber, you detailed the payments made to him.
That's correct, Chairperson.
And then you confirm that that's at table 21 at page 936. You confirm the correctness of what's there.
That's correct, Chairperson.
And just to, again, indicate why you likely highlighted or auditors earlier, at 14.8.5, you make the point that leasing's auditors are Landgräber, but the auditors for holdings are Van Wyk auditors.
Yes, Chairperson.
Then at 14.9, you detail payments linked to Musa Capital, and obviously through that, Ms. Cynthia Parrish. This is the American citizen.
I'm sorry, Mr. Son, you say at what?
Sorry, 14.9 on page 937.
Okay, yeah. If you could just mention the page number
Yes,
together
yes,
with the
sorry.
paragraphs, that
Yes.
will help. Yes, okay, all right.
And this appears at table 22 on page 938, and you confirm the details as set out in table 22, Mr. Sacks.
That's correct, Chairperson.
Then 14.10 are the payments made to Sebenza, and you detail these at paragraph 14.10 and table 23.
That's correct, Chairperson.
I'm not going to ask about this because in the auditors, in Mr. Mashaba's note in respect of the payments to Sebenza, he says that Swifambo in fact had paid 110 million, not 99 million. And so we'll look at that. That's effectively the head of Swifambo saying that that's what the amount is.
Yes, Chairperson.
And I'm not saying that your figures are wrong. I'm just saying that if they say they paid that.
We must just remember, Chairperson, at the time I performed my investigation, I wasn't privy to documentation out of Swifambo. I was purely looking at bank statements, and obviously...
And you didn't have all the bank statements in any case.
Yes.
Some of these may have been from those other bank statements.
Yes, Chairperson.
Did you get to know around about when Mr. Srisobutelezi ceased to be a director of Sebenza Forwarding? Or is that something you never got to know?
Chairperson, I don't have that date in my report. I would have obtained this information from CRPC, so it should be readily available. But I did note in my report that he was a previous director. I just, at this point in time, I didn't tell.
It would be good to get that information to see at what, as from what date he ceased to be a director.
Yes. Mr. Sacks is going to prepare a supplementary affidavit. We will include that
Okay,
as well.
all right.
Then at paragraph 14.11, you deal with the payments linked to Nkosi Sabelo, and you say there were two payments again on account of the fact that Mr. Mashaba sets out the payments that he made to this firm of attorneys and the reason for the payment. We will deal with this part or these payments when we deal with his note on the CM10 relating to these payments.
Yes, Chairperson.
Does paragraph 14.10.5, which is based on Mr. Mamabolo's affidavit, which says that Mr. Butelezi the previous former chairperson of PRASA board, had a 15% shareholding in Cadiz, which says has a 55% shareholding in Sebenza Forwarding. Does that mean that even though he may have resigned as a director of Sebenza at some stage, throughout the time of this Swifambo transaction, while he was chairperson of the board, he had this connection with Cadiz that has a 55% shareholding on Sebenza. Do we know that?
Chairperson, these were allegations made by Mama Vossloh.
Yes.
I cannot confirm if those allegations are true. However, it was included in my report because it certainly warranted
some
further. Further. But you are correct in saying that whereas this individual might not have been a director, he might have had an interest, an ownership interest in the Sebenza.
Yes.
Is it possible to look at CIPC documents and include this in the further affidavit?
Chairperson, CIPC doesn't include shareholding. That information is not readily available. So that's why it has to be performed per subpoena or investigation.
Yeah.
Oh, so only the police would be able to do that?
That's my understanding, yes, Chairperson.
Yeah. And I guess if the police can do it, the commission could do it as also.
Oh, yes.
In terms of issuing a summons to produce documents.
Yes.
Yeah. Okay, all right. I interrupted you, Mr. Son.
Sorry, Chairperson, we're at page 945. These are the payments linked to Mizani Engineering, and you say there were 14 payments of 2.5 million rand. They are reflected in table 25. You confirm that what is set out in table 25 is correct?
That's correct, Chairperson.
And then the payments linked to Mizani Investments. I take it these are different entities, Mizani Engineering and Mizani Investments. Because one is at 14.12 and the other is at 14.30.
Chairperson, these are bank accounts with the names. I tried to address, if I could, in the investigation, if I could identify who the company was behind. Hence, I included auditor and CRPC information. But this is the name of a bank account.
And of course, if you look at 14.2.2, you'll see that the auditors are Van Wyk auditors for Mizani Engineers. And if you look at 14.13.2, the auditors of Mizani Investments are also Van Wyk.
Yes, Chairperson, that's correct.
So this is the name that kept cropping up, and that's why I suppose you flagged it and thought it is something to look at, not that there's something wrong with it.
Yeah. Yes, Chairperson.
Then at 14.14, you deal with a payment made to Knowles Hussein Lindsay attorneys. Again, this payment is dealt with by Mr. Mashaba in a note to his CM 100. I'm going to go through that with you in a little while, Mr. Sacks. So I'm not going to deal with it here. And then, of course, the payment linked to SARS. I mean, that's not a matter that concerns us at all. And paragraph 15 on page 953 is the matter we've been through already.
Yes, that's correct. The payments from Vossloh, Chairperson.
Now, before I go on to the next set of documents I want to refer you to, I want to refer you to page 873 of your report. And this is where you make the allegation, or you say...
I guess just for the transcript, Mr. Soni,
as
and
you
those who
please.
read afterwards, when you said page 873 of the report, it's 873 of the bundle.
Of the bundle, sorry.
The page
Yes,
for the report
yes,
will be
yes.
not that.
No, sure. Yes, quite. And that's bundle L.
Yes.
Now, I did mention it earlier, and I said I was going to raise this matter with you. In paragraph 11.38, so sorry, I'll just take you back to the context. You were raising matters that had been raised with the key people at PRASA. And at 11.37, you made the point that according to Mr. Molefe's affidavit, certain matters had been brought to the attention of Mr. Montana, but he ignored them. So that's not what I wanted, but that's the context. At 11.3.8, you say, Bridget Gaza, now let's just identify her. What was her position in PRASA at the time?
Chairperson, I'm not absolutely familiar.
Okay, she was a member of the board.
I understand she was a member of the board, yes. That's correct, Chairperson.
Now, the point you made, though, is based on what had been said in Mr. Molefe's affidavit, she had raised serious concerns about Sufambo in an email dated the 6th of November 2012 to Mr. Buthelezi and Montana. Let's just deal with that. Have you managed to lay your hands on a copy of that email?
Chairperson, a standard procedure in the Worksman's investigation, the team they forensically secure the documentation from the outset of the investigation, and in this case there was about 1.4 billion documents, and within these documents, this email that Council refers to was located, and I'll read the contents of this email.
Well, before you do that, Chairperson, I have a copy for you. It may be easier for you to follow it. May I have leave to hand it up? And we will obviously include it in the further affidavit of.
Okay,
so
that's
that,
fine.
But at least for now,
Yeah.
you have it informally, and then it'll formally be part of the record.
Yeah, that's fine. Thank you.
So let's just put this in context. Ms. Gaza writes on the 6th of November 2012, and she writes at 1925. When I say writes, it sends the email at 1925. Is that correct?
That's correct, Chairperson.
Who were the recipients of this email?
Chairperson, the recipients of the email was an email address safiso@makana.co.za, and as noted on the email, second recipient was Lucky Montana, PRASA Corp.
All right. What does she deal with in this?
Chairperson, this email deals with her raising the serious concerns, And if council indulge me, I can read into the record.
If you could read into the record.
So the subject is urgent. The attachments to this email states Wafamba Rail Leasing Doc X and Mpumalanga Doc X. And the email reads as follows. Colleagues, I know you are both in Cape Town trying to rescue our organisation from being hijacked. I appreciate your efforts and can only hope the plot will be successfully arrested. Unfortunately, I am not a bearer of good news. I've just received intelligence information about Swifamba Rail Leasing, the company the PRASA board approved 3 billion rand worth of work over 15 years. With all these platforms not being safe, I would like to request that you allow me to dig a little deeper. Failure to follow this up would sink the organisation. Should the intelligence report prove true, we need an immediate intervention as the board. Signed off by Dr. Bridget Gaza, MD, the Eliox Group Pty Limited.
Now, this seems to indicate that there was an attachment to this email. Do you know? Well, I mean, obviously, you picked this up from Mr. Molefe's affidavit. Or what, Mr.
Ms. Molefe obtained this document through the Worksman's investigation, through the repository of the forensically secured documents, as I mentioned. I would imagine, to answer your council's question, if there was an attachment, it could be, I would have to be confirmed that this would also be, that if this email was located in the forensic process, then the attachments would also be. I'm not familiar, as I wasn't part of that forensic process.
Chairperson, I want to deal with the second email and, having regard to its contents, make a submission to you on how we can take that issue forward, Chairperson.
Yes. Obviously, she was very troubled.
Yes.
By the intelligence report that she says, intelligence information that she says she had received about Bombardier listing. And she asked to be afforded more time to look into whatever was said in that intelligence information. And she says, in effect, if we don't follow up this intelligence information, that failure will sink the organization.
Yes.
And should the intelligence report prove true, we need an immediate intervention as the board.
Yes. She makes another important point here.
Yes.
We've looked at this as a contract for so many locomotives.
Yes.
But if you look at what she says, this is 3 billion rand worth of work over 15 years.
Yes.
Now that's even more worrying because, as I understand it, the state contracts are not to be beyond a certain period, 3 years or 5 years. I recall in one of the Mr. Mkwetu's affidavit, he flagged that as an irregular expenditure because it exceeded 3 years.
Yes. Yes. You may continue.
I want to come back to how the approach the proposed approach we should adopt.
Yeah.
And then there is a reference to a second email, and that is from Ms. Gaza again. What is the date of that email?
Chairperson, that date is 20 November 2012,
And the time?
10:38 a.m.
And who is the email addressed to?
Chairperson, again, the email was sent from Bridget Gaza, and it was sent to Chris Mbata, PRASA Corp, copying Lindy Kaya Zeed, and safiso@makana.co.za, the subject being follow-up on the Swifambo rail leasing.
Lindy Kaya Zide, I assume, is the one that at some stage became company secretary and at some stage acting group chief executive officer.
Yes.
And Sfiso at makana.co.za, that seems to be the same email address that we associate with Mr. Sfiso Buthelezi in the previous email.
Yes, yes, it's the same email address.
Yes, okay. So it's about 2 weeks after the first email.
That is
Yeah,
true.
okay.
Please read that into the record, Mr. Sacks.
Chairperson, the email reads, Dear Chris, I'm once again making an attempt to extract more information from you and the procurement team on the above-mentioned matter, as per our initial discussions of the 8th of November. It is imperative...
Just sorry, 1 second. She says, our initial discussions of the 8th of November, that is 2 days after the email to Mr. Buthelezi and Mr. Montana.
That's correct,
The one
Chairperson.
you just read, yes.
It is imperative that PRASA as an organisation appoints adequately capable entities to undertake the work under all of its programs. Moreover, when our contracts are high in value and are linked to the strategy of creating new industrialists in the rail sector. There are concerns that have been raised around this particular entity, and the FCRP is needing you to confirm that indeed a capacity check was properly done in relation to this contract and that you have satisfied yourselves that the necessary checks and balances have been done. Please proceed to provide me with the information I'd requested from you, as time is of the essence, and it would be an anomaly to proceed to conclude contract negotiations in light of the seriousness of the matter we had raised, for which we have not received a response from you on. Kind regards, Dr. Zanele Bridget Gaza.
So, in terms of the last part of her email, it would appear that she had not, that is Dr. Bridget Gaza, she had not received information that she had requested with regard to this transaction. Whether she's talking about information she may have previously requested from Mr. Chris Mbata, or she's talking about the information that she may have requested from Mr. Montana or Mr. Buthelezi, one might not be sure, but it's clear that she had been seeking confirmation, she had been seeking certain information about this transaction.
Yes.
And she says she had not received a response. And it's clear from this email that her concerns include the capacity of Swifambo in terms of this project. Is that right?
Yes.
Because I think in the email she refers to capacity, does she not?
She does.
Yes, she
That's
does.
correct.
Second paragraph of the second email. There are concerns that have been raised around this particular entity. And the subject is follow-up on the Swifambo rail leasing. There are concerns that have been raised around this particular entity, and the FCIP is needing you to confirm that indeed a capacity check was properly done in relation to this contract, and that you have satisfied yourselves that the necessary checks and balances have been done. That's a very important issue she was raising. And of course, now that we know what we know, if they had taken heed of her concerns, maybe PRASA and the taxpayers wouldn't have lost the kind of money they lost out of this.
Yes.
So that's quite important. Well, it may well be that it might be important to explore the possibility of calling her, because she might be able to tell the Commission much more in terms of
Absolutely.
what were other issues that she raised in the discussions at board level. And I think, of course, Mr. Montana should be coming in due course, but Mr. Buthelezi, it looks like, would need to come as well to give his account of what he did or didn't do in response to these concerns, when we now know that Swifambo had no track record and no capacity to deal with these matters. Yes.
Chairperson, this is what I was going to propose, and that's just to expedite the outcome that you want, is we send, instead of sending a Rule 33 to her, because there's no implication in respect of her, is to send her a 10-6 directive.
Yeah.
To say,
yeah.
we have these two emails.
Yes.
These are the concerns that appear to be raised.
Yeah.
Would you please prepare an affidavit by whatever date that deals with it, with the matters you've raised? The reaction to these emails, we don't know if there was a reaction. And as you've pointed out, Chairperson, what was the board's approach? Did you raise it at the board? And what was the board's approach?
Yes, but slightly different, but same thing, but slightly different approach. Rather than saying, will you tell us, I would say somebody must try and reach her over the phone and say, this is what emerges, and we would like an affidavit for you, and we would like to prepare it for you. We can have a Zoom consultation. You tell us all that you can share with the Commission about the concerns you had, that you raised, how did everybody respond to them, the discussions at board level, and on the day that the deal was approved by the board, what were the discussions? I take it if we don't already have minutes of the board meetings, particularly when they approved, we should try and get that so as to see whether the whole thing just was going through the motions, or whether there was a serious and proper consideration of the issues. But she may have been there and she could know. So if she gives all the information she knows, then somebody within the legal team can prepare that affidavit, then send it to her. It might be a matter of within a week we might have an affidavit from her. So yeah, it's the same things, just a
Absolutely.
yeah. Okay.
But what we now know based on those, that certain persons at least can't claim ignorance, that they were not aware, they were not alerted. And in law, Chairperson, is if you have a duty and you ask to investigate and you don't investigate, that's a breach of the duty.
Yeah, no, these emails are very critical for all those that they were directed to. And it may well be that in board meetings, in certain board meetings, she raised the same issues. So everybody who was a board member knew what the issues were. Yeah.
And therefore the net might spread wider in terms of implicated persons.
Yes. I mean, one of the one of the things that the Commission is looking at with regard to SOEs is where boards of SOEs didn't do their job properly. What must be done? And was it a matter of incompetence, or could it be that the board or some members of the board were party to some agenda which was against the interests of the entity? But also it's important because it may well be that I could consider that subject to issues of prescription and so on, the entities should sue them.
Yes.
To recover whatever they can recover of the taxpayers' money.
Yes.
And also the Commission will need to look at what qualities should people who get appointed as directors of these SOEs have. Because it must be people who have integrity, and it must be people who are prepared to make decisions that are in the best interest of the entity and not other decisions. I mean, an obvious thing with regard to this is when the board approved this, what information did they have before them which indicated that Swifambo was an entity that could be given this kind of contract?
Yes.
What did they know about this entity?
Yes.
You can't just make a decision without doing, getting a certain amount of homework to be done.
Yes.
Particularly when it's not your money.
Yes.
You are supposed to look after the public, after public money. So we have got to look at all of those things because there ought to be some change in how things are done in these SOEs going forward.
Yes.
And this commission is in a position to come up with recommendations to say, going forward, these are the things that should change. Then it's up to the president if he accepts the recommendations or not, but the commission has a duty to look at why certain things happened at SOEs and what should be done to make sure they don't happen again.
Absolutely.
Yeah.
Now, Mr. Sacks, we've dealt with your report, and I know, and this was a long time ago now, you indicated what the purpose of the report was. You handed this report, and we've dealt with the issues that arise from it, even if one doesn't know all the facts. What did you expect would happen next after you'd submitted the report, and also you'd made a presentation? What did you expect would happen next?
Chairperson, I think it goes without saying that I expected the investigation to continue. It's simple as that. Obtain the information I required, be in a position to perform the second level of analysis required, ultimately with the objective of concluding, forming an opinion, and advising law enforcement who had engaged me of what my view. The report within itself speaks volumes as to what the findings were already. And I guess the remaining information we've just confirmed further and pointed to other areas that needed to be to investigate for criminal proceedings to proceed.
If you had been asked after the presentation or shortly after your report or any time after your report, do you think any purpose is going to be served by continuing these investigations that you've largely, well, not fulfilled, but you've started this process? What would have been your approach?
Chairperson, to ask Council my approach in performing the investigation.
No. What would have been your reaction to a question of that nature? In other words, should this matter proceed? Is it worth it in terms of money, time, and possible outcome?
Chairperson, I think the records, the report, or the information contained in the report stands for it on its own, and that's, yes, the investigation most certainly should have proceeded.
Now, of course it didn't. And you were not even briefed on the Siangena matter, which was going to be the next brief from the Hawks to you, is that correct?
That's correct, Chairperson.
Chairperson, that obviously is the question, who should be held responsible for that? We can see the outcome, and we see where PRASA, the PRASA Sufambo contract is and the actual losses that have been incurred. Of course, the liquidator will come in after Mr. Sacks to explain what the position is at the moment. But whatever the position is, from a position of good governance, somebody ought to be held responsible for not requiring, not only allowing, but requiring Mr. Sacks to pursue to the logical conclusion this investigation that he had started.
Yeah, no, that's true.
Now, Mr. Sacks, after you presented your report, you've not heard from the Hawks since.
That's correct, Chairperson.
Now, you've heard what I've indicated to the Chairperson should happen about that. I want to take you to something else. You have now been shown a report prepared by the liquidator of Swifambo Holdings and Swifambo Rail to a report to stakeholders dated the 18th of February 2020.
That's correct, Chairperson.
And in asking you to prepare for the presentation of your evidence, I've indicated to you I'd like you to just consider having regard to the flow of funds that he sets out and comparing it to what yours are. Or the general impression created by the flow of funds. What is the difference in views, if any?
Chairperson, the liquidator's report corroborates the findings contained in my report with regards to the flow of funds. As simple as that.
Not necessarily in every detail, because you didn't have all the information. With the further information he has, it reinforces the correctness of the conclusions that or the correctness of what you have set out in your report.
That's correct, Chairperson.
And all one would need to do is just add the further investigations that have been done since as a result of the powers that he had.
That's correct, Chairperson.
Right, but there is nothing in his report that raises concerns about the cogency of your report.
That's correct, Chairperson.
Now, then can I ask you, I also said to you that after the liquidator had submitted...
Maybe before you proceed, let me just get this clarification, Mr. Sacks. Is it correct to say when one looks at what one can call your findings in your report, one should limit one to the flow of funds section, because whatever came before that was just the background that would make the flow of funds section understandable. Is that correct?
Chairperson, you are correct. I include, as you correctly state, I included all that background information, but my actual mandate
Yeah.
was the flow of funds, and that was,
Yes.
I guess, as our detailed, that was my detailed findings.
Yes, yes. And of course, part of the reason why I'm raising that is that you will remember yesterday, I tried to establish what was preliminary and what was not preliminary in your report. And you did say that the report was a draft preliminary report, but you did say there are parts of the report which reflect your finding. And I think what you are saying is that your findings are only those that relate to the flow of funds. And I guess that because if money did leave account A and went to account B, that's not going to change. That's fine now.
That's correct. That cannot ever be disputed.
Yes, yes. Okay, all right. Thank you.
As you please, Chairperson. Sorry, before I deal finally with the report, I've been told that there is a report in the Swifambo application which deals with a comparison between what the tenderers, the different tenderers had tendered. Are you aware of that?
Chairperson, I am aware of what was contained in the Popomolefe affidavits.
Right. Now, in light of the fact that the chairman has indicated that is a matter that must be taken into account, I'm going to ask that you look at the report and indicate in the supplementary affidavit precisely what is contained in that report as a comparator between what Swifambo was charging and what other tenderers were charging.
Okay, Chairperson, I'll attend to that.
The background to that, Chairperson, is apparently it is said by Judge Francis that the tender, if the specifications imposed by Mr. Mtumkulu had not been taken into account, another tenderer would have won. But apparently there is a report which sets out precisely what that is, and we just don't want to be talking without all the relevant facts. But it may also then raise further questions about the bona fides of the decision that was taken. But we will get Mr. Sacks to, but I thought before he leaves, you ought to know, Chairperson, that would be a further matter that he will address in his affidavit.
No, that's fine.
Right. Now, in his report, the liquidator filed his report to stakeholders on the 18th of February 2020. Thereafter, in July, Mr. Mashaba filed a second CM100 in respect of each of Swifambo Holdings and Swifambo Rail. Now, I just want to ask you if you've had an opportunity to look at the new CM100s. Sorry.
Yes, Chairperson, I have.
Chairperson, I just want to, I know Mr. Sacks is not was not the recipient of it, but obviously when you see what the CM10 deals with, or some of the matters it deals with, it goes into some of the issues he has raised in his report. And I thought it's only fair that Mr. Sacks be given an opportunity to say, now I see that, and I accept that to the extent that Mr. Mashaba says this, and it's consistent with the bank accounts, I cannot have a difficulty with it, having regard to the fact that I didn't have all the information that the police should have provided me with.
Okay.
So I'm going to ask you, sorry, Chairperson, we are now dealing with bundle C1 and it's exhibit SS4. That's the liquidator's report to stakeholders.
Are we using red numbers here?
Red numbers on the right-hand side, as you please.
Yes, you may proceed. We're
As
at
you
page
please.
159, eh?
No, page, I'm not going to, the liquidator will deal with the report, it's just those matters that concern Mr. Sacks. And they are dealt with starting at page 214.1.
214.1.
Yes.
Okay, all right, I've got it.
Because I should just indicate by way of background why that numbering is like that. The liquidator, when he filed his report, obviously didn't have the revised CM, well, the new CM10 hundreds. They were included after our consultation with the liquidator because we indicated to him the importance of tying up the two reports, the liquidator's report and Mr. Sacks' report. Now, page 214.1 is the first page of the new CM100s in respect of RailPro Holdings. You see that?
Yes, Chairperson.
Do you know why it's now called RailPro Holdings?
Chairperson, I'm not familiar why RailPro Holding, or I don't know why it's called RailPro Holdings, to answer the question directly.
Okay, you can take it for granted that refers to Swifambo, what was Swifambo Holdings.
Yes, and I have seen that it's the same bank account as Swifambo Holdings.
Okay. But the name has been changed to RailPro
Yes,
Holdings.
yes, Chairperson.
Now, in regard to that CM document, the CM100, the date of that document is the 6th of December 2018.
Yes, Chairperson, on page 214.3.
Right. Then at 214.18 is a so-called replacement CM100.
I see that, Chairperson.
Now that is dated, and you'll see it on page 214.20, that is dated the 13th of July.
That's correct, Chairperson.
Now it is this that I don't want to go too much into RailPro Holdings, but except in note 2, which appears at 214.35. Sorry, can I just ask you, in respect of notes to CM, are you familiar with that, or should I rather leave it to the
I'm not familiar with it. Okay. I would have, it looks to me, in my view, as just additional information that's being provided.
But what is said there is that All Material Towns Holdings was a non-trading entity. 2, at All Material Towns Holdings permitted leasing to deposit amounts into its account on the basis that such amounts were the property of Sufambo Rail Leasing, and for reasons that are unclear, Holdings entered into contracts with certain service providers, including its auditors, on the basis and understanding that all liabilities arising therefrom were payable by and or for the account of leasing. And Holdings accordingly is entitled to recovery from, leasing is entitled to, Holdings is entitled to recovery from leasing.
I see that, Chairperson.
That's what, I just thought I'd tell you that that's the relationship that is now said to have existed between Sufambo Holdings and Sufambo Leasing. Okay. Now, for present purposes, we needn't go much further than to say that at page 214.38, the original CM100 in respect of Sufambo Rail Leasing was filed. And then, if you look at page 214.56, a new CM100 in respect of Sufambo Rail Leasing was filed.
I see that, Chairperson.
And that is dated about the same time as the second CM100 in respect of holding.
That's correct, Chairperson.
Now, I just, so that we all know what we are looking at, I want to ask you if you could just please turn to note 1, which appears at 214.70. Oh, sorry, before you go there, I'll just ask you to look at page 214.63 and 214.64. This lists the creditors of leasing. Would that be correct?
Chairperson,
214.63.
214.63, it records debts due to the company, so it's assets.
Yes.
Debtors.
Sorry. The
Debtors.
Debtors of leasing.
That's correct, Chairperson.
Yes. Now, and in respect of each of them, there is said to be a note.
That is correct, Chairperson.
I want you to look at, though, at page, at note 1, which appears at page 214.70. Because this deals with what Mr. Mashaba now says, or is the basis on which leasing has claims against the various debtors that are reflected in those pages I've referred you to. And if I could just quickly go through, I just want to, he says, on the 6th of December, Oswald Mashaba purported to sign a CM 100 statement of affairs. And then on the second paragraph, he says, AHAM has been advised by Attorney Cameron, that's Oswald Mashaba has been advised by Mr. Cameron to prepare a new statement in order to comply with the sections of 366 of the Companies Act. And he has engaged the previous auditors of leasing to perform a forensic audit. And he says this is the outcome of the audit.
I see that, Chairperson.
Okay. Then can I ask you to go to page 214.108?
Please just repeat the page, Mr. Sonny.
214.108, Chairperson. So if you could keep your finger on page 214.63 while we are looking at this, because you will see that note 19 refers to its claim or its alleged claim against PRASA, and you will see that at the top of page 214.64.
I see that, Chairperson.
All right. Now, he says at paragraph 3, and remember you've indicated the amounts that leasing and holding have received from PRASA. He's indicated the link between PRASA, between leasing and holding. At paragraph 3, he says, Oswald Mashaba has been advised that the sum of 109 million rand remains to be recovered by leasing from PRASA and ought not to be offset against any claim that PRASA may have against leasing.
I see that, Chairperson.
What is your reaction? I mean, it's not for you to, I'm not asking you to comment, but just looking at the flow of funds as you have outlined, and as you say, is more or less confirmed by the liquidator's report on the same issues. What is your reaction to that?
Chairperson, this is a claim regarding payments that Mashaba said that Swifamba paid to Sebenza. Other than confirming the bank records of Swifamba and my analysis that Sebenza received 99 million rand, Mashaba purports or claims to have provided supporting documentation for those payments. If you recall, Chairperson, the contract between Swifamba and PRASA says the cost of shipping and forwarding is for the cost of PRASA. So other than this paragraph 3 confirms that Swifamba made some payments to Sebenza that is claiming from PRASA.
But he goes further and he says PRASA must pay this before its claim against Swifamba can be determined.
Chairperson, based on what I see in my reports, these are Mashaba's claims. I don't know what credence could be given to his claims. Based on his other claims contained in this document, which I've read, I understand what council is asking, but it needs to be seen in context of the bigger picture. I think simply put, he's saying that, Mashaba is saying that, well, Swifamba made payments to Sebenza, and those payments must be paid to, Swifamba must be reimbursed by PRASA. I'm not sure on the legalities of whose claim supersedes whose, but that's how I read this document.
Okay. Maybe the liquidator, because he is the person who is looking after PRASA's interests, will deal with that.
Ultimately, Chairperson, it's a point that you so put as what is for 13 locomotives, 100 million rand, how much money was PRASA paying to bring one locomotive into South Africa? Here is, which wasn't available to me at the time, but before my analysis, here is internal documentation from Swifamba that talks to these payments. And this would be a starting point for an investigation to say, yes, Benza's purported tax invoices as provided by Mashaba in his affidavit. That will be my first point of investigation. Let's go analyze this documentation, which myself, perhaps the liquidator has, which the liquidator would do in the ordinary course of assessing claims. This documentation would be investigated further.
Then can I ask you to look at note 22 and keeping an eye on what 22 refers to. This refers to the claim of Mr. Mabunda.
On page 214.130.
Yes.
Sorry, yeah. But if,
Yes.
and I'm saying that's confirmed by the fact that at page 214.64,
Yes,
he flags it as note 22.
yes.
Oh. Now, what does he say about his claim? Can you read that, Mr. Mabunda's claim, please?
Chairperson, what Mr. Mashaba says about payments in the amount of 28.8 million rand that's reflected on the schedule on 214.64. Oh, sorry, I lost my page.
That's page 1, it's 214.130.
So with reference to those payments, when Swifamba made, or Mr. Mashaba claims that Swifamba made payments of 28.8 million rand to Mr. Mabunda, and in Mashaba's view on note 22, he states, Mr. M. Mabunda, although having offered advice and having made available consultancy services through a number of entities forming part of the S Group, was never employed by leasing, and accordingly it is not understood apparent as to why he received various amounts and in aggregate an amount in excess of 28 million rand. By virtue of the foregoing, it is contended that MM, being Mr. Mabunda, is indebted to leasing unless Mr. Mabunda is able to furnish information and or documentation indicating the legal basis upon which he received various amounts from leasing.
Now, when you were identifying the entities from which Mr. Mabunda had received money, the Swifambo entities, it was quite clear that all that money came from Swifambo entities. Is that correct?
That's correct, Chairperson.
And those entities were effectively under the control of Mr. Mashaba.
Chairperson, Mr. Mashaba doesn't state, he just gives a total amount, whereas in my report I detailed which payments make up the amounts that are categorized as a Mashaba payment, linked payment, or Mabunda linked payment. In this instance, Mr. Mashaba just throws a number out to answer Council's question. In my view, if I must say, please, this statement is nonsensical, whereas Mr. Mashaba claims to be the managing director of a company. Now he's stating, I don't understand why he received 28 million rand. This makes no sense.
Although the companies that made those, I am the managing director of the companies that made those.
Yes, Chairperson.
Then can I ask you to look at note 25, which appears at 214.133. And this is the payments made to Mr. Sabelo and other people, and perhaps what I should ask you to look at is page 214.135, which is the next page, where he schedules these claims. See that?
I see that, Chairperson.
I'm just trying to present the context.
Yes.
So if you could tell the chairperson what he alleges this claim against these individuals is for.
In summary...
No. It is important that we know what his case is.
Chairperson, I'll start at the back and work my way. I'll work my way back. So on page 214.134, Mashaba contends, by virtue of the foregoing, the donations by leasing for the benefit of the ANC never reached the ANC, and MG being Maria Gomez and GS being George Sabella having have unlawfully received and retained the sum of 79.4 million rand, and accordingly these amounts are refundable to leasing. So it's in essence what Mr. Mashaba is alleging is that leasing, so Swifambo Rail Leasing made payments in the amount of, as shown on page 214135, made payments to, well, the schedule, he calls a schedule of donations to ANC. He lists payments paid to Nkosi Sabelo Incorporated, NCR paid into trust accounts of Knowles, and then 5 payments to Similex, which I'm assuming he hasn't totaled it up on his schedule, which I'm assuming adds up to 79.4 million rand. So he's saying Swifambo made these payments, but there's no rationale for these payments, even though it's his company, and they must be recovered from the recipients being Maria Gomez and George Sabelo in the amount of 88 million rand.
In the context of why he says these payments were made, it's strictly speaking intimately connected with the award of the contract. That's why I wanted you to read from paragraph 1.
Okay, sorry, excuse me, Council. So I'll read from paragraph 1, note 25. Shortly after leasing was awarded the locomotive tender by PRASA, Mr. Mashaba and Mr. Mabunda were approached by 2 individuals who held themselves out to be fundraisers for the African National Congress, ANC. The 2 persons referred to in one were Mrs. Maria Gomez, MG, who's MG, and attorney George Sabelo, at that stage a partner shareholder in a legal firm by the name of Nkosi Sabelo, and that's GS, George Sabelo.
If you could just stop there. He says here that this was after the award of the tender. You remember that? I mean, you
Yes,
note that?
I see that, Chairperson.
Now, I don't need to go to this, but you'll recall that in his affidavit, replying affidavit in the Swifambo matter, Mr. Molefe had said that Mr. Mabunda had approached Mr. Mashaba and asked him to be the front of the tender that still hadn't been issued. You recall that?
I recall that, Chairperson.
Yes. Okay, I just wanted to make the point that this is inconsistent with what he said to Mr. Molefe.
That's correct, Chairperson. To carry on reading paragraph 3 of page 214.133, under pressure from Gomez and Sabelo, Mashaba, on behalf of leasing, agreed to arrange for a donation to the ANC of an amount equal to 88 million rand, and which would be dealt with as follows. Mashaba would receive a handling fee in the region of 8 million rand, and the balance in the sum of 80 million rand would be paid as and when directed by Gomez and Sabelo. At that stage, it was indicated to Mashaba that a company owned by Sabelo, being Similex Pty Limited, would generate invoices to leasing. Arising from the foregoing, payments were effected to Gomez and Sabelo, and in aggregate the amount of 79.4 million rand as indicated in the schedule which is annexed hereto as Annexure A. At a Section 417 inquiry, Sabelo testified that he had never been paid a fundraiser for ANC, and the only part that he and NS played in leasing was to collect amounts invoiced by Similex to leasing, and whereafter he dispersed the amount received, presumably into the trust account of NS as directed by Maria Gomez. By virtue of the foregoing, the donations by leasing for the benefit of the ANC never reached the ANC, and Gomez and Sabelo have unlawfully received and retained the sum of 79.4 million rand, and accordingly these amounts are refundable to leasing.
So that's his claim now in respect of all those amounts, because you'll see that the amounts paid to Knowles, Hussein, Nkosi Sabelo, and Similex are all included in this total amount.
That's correct, Chairperson.
It's one thing that I thought may be worth pointing out, and that he had agreed to pay 80 million rand. This is Mr. Mashaba. But he was going to charge a handling fee, if you look at paragraph 3.
Yes, I see that, Chairperson.
And so the amount that was going to go to the ANC was 80 million rand. His handling fee was going to be 8 million rand. Do you know where that 8 million rand was going to come from?
The 8 million rand came from PRASA, Chairperson.
Then can I ask you to please look at note 32 on page 214.149. Now, this here refers to, if you go back to, you don't need to, but it refers to the payment made to the S Group or Mr. Mabunda by by Vossloh. That's the 75 million rand we were talking about.
That's correct, Chairperson.
What does he say about that?
Chairperson, if I may read from this page 214.149, note 32, paragraph 1, subsequent to leasing concluding a subcontract agreement with Vossloh for the sale of 70 locomotives, and without the knowledge of leasing and its consent, Vossloh paid to Mr. Mabunda S Group an amount of approximately 75 million rand. It is Mashaba's contention that this amount should have been paid by Vossloh to leasing as some form of rebate, and according to leasing liquidators, need to recover this amount from Mabunda, the S Group.
So this money he now wants the liquidators to recover from Mabunda, as he wanted the earlier amount that Sufambo had paid to Mr. Mabunda.
Chairperson, in my mind, this is Mashaba's contention, his view, but all it does, it confirms to me that Mabunda received the 75 million rand. The commercial rationale, as Mashaba is talking over here, well, I don't know, any conclusion can be drawn.
But doesn't that reinforce the point you made much earlier, that didn't seem to be any commercial rationale for many of these transactions?
That is correct, Chairperson.
All right, and then the final one I want you to look at is note 33 at page 214.150. Now this you will see are payments, if you look at page 214.65, this relates to payments made to the CIA group.
That's correct, Chairperson.
And what does he say about that?
To read from page 214.150, note 33, from time to time, CIA consulting engineers was paid amounts totaling 7,243,773 rand. See Annexure A here too. Mashaba bears no knowledge as to the reasons for these payments and accordingly disputes that CIA was entitled to these amounts. The only documents that have been located in regard to the alleged services rendered by CIA to leasing are annexed here too. In regard to the alleged scope of work detailed in Annexure B4, Mashaba disputes that the consulting services indicated therein were ever rendered by CIA to leasing, and accordingly the liquidators of CIA, one of whom is Muller, who is a co-liquidator of leasing, should be called upon to investigate whether these services were rendered by CIA to leasing. In addition to the foregoing, the leasing liquidators should lodge a claim against the solvent estate of CIA.
The CIA too is under liquidation, or has already been liquidated.
So I've been informed of that, Chairperson.
Well, he's talking about the insolvent.
Yes, sorry, Chairperson.
So, what is quite clear from these is the main payments that were made to Mr. Mabunda and his companies, either by Sufambo or by Vossloh, this is Mr. Mashaba is saying, must be recovered from Mr. Mabunda.
That's what Mashaba is claiming, Chairperson.
And he's also saying that the money that was paid purportedly for the benefit of the ANC, which didn't receive the benefit, according to him, must be claimed back from those whom he gave the money to because he believes it was for the ANC.
I agree with that contention, Chairperson.
And again, come back to your report. As you were going to your report, you said, but it doesn't look like they did anything in respect of the contract at issue, contract that PRASA or the Locomotive contract itself. And in respect of what he says now these are, what is your, how do you feel about what you had said earlier?
Chairperson, Mashaba confirms that all these amounts dispersed by Swifambo were of no benefit, at the very least to Swifambo, had no purpose. He's even claiming they should be paid back, even though he was the one, I would imagine, as the managing director, if not made the payment, approved the payment. But in summary, these payments had no commercial rationale.
Chairperson, I see it's 1 o'clock. Those are the issues I wanted to raise with Mr. Sacks. I don't know whether you have any issues that you want to raise with him.
No, I wanted to make sure that, if possible, we adjourn for lunch only when you are done with him.
Yes.
If you are done,
I'm done.
you are done. Yeah. Thank you very much, Mr. Sacks, for coming to assist the Commission. Should the need arise, we'll ask you to come back, but we hope that, or you may have to come back because you have some homework to do for us. But some of that homework maybe might just be supplementary after this that get filed with the Commission without the need for you to come back to give oral evidence. But I've no doubt that if we do need you, you will avail yourself.
Thank you, Chairperson.
Thank you very much for assisting us.
Yes.
We are going to
and
take
from the team as well.
the lunch adjournment then, and then we will resume at 2:05.
As you
Yeah, we adjourn.